Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. It's time to talk about some of our sponsors, and I'm doing that today with Robert Ingalls from Law Pods. Rahul's out today. He's unfortunately been affected by the wildfires in Los Angeles, and we hope he can be back soon. He was evacuated from his home, but I'm very happy to say that just today I heard that he was back in the home, Robert. So,
yeah, I'm not nearly as clever as him, but I'll do my best on this one.
Okay, appreciate your standing in for him. So today's episode is brought to you by Steno. Steno is a company that has rethought court reporting services. Not only do they allow plaintiffs' trial lawyers to defer the cost until the end of the case, but they've developed their own interface that allows you to better handle and manage exhibits and visuals during the deposition. Check them out.
And what is it about Steno that you really feel like is their main thing? What makes them special?
You know, I think it's really critical for lawyers to have that option to defer the costs of depositions, particularly in cases where you're doing dozens of depositions. It can be a very significant part of the overall case costs, and it's nice not to have to incur that until you get your money in at the end of the case.
And you can listen to the Season 4, Episode 17 with Steno President Dylan Ruga. We'll link that in the show notes for you.
Yeah, Dylan's a great guy and a really interesting episode, so I encourage you to listen and see what they're all about. Our show today is also brought to you by our friends at Expert Institute. They've been a sponsor of this show since the beginning. My good friend Michael Talvey was on the show, and Robert can tell you when that was. What was his episode, Robert?
So we had Michael Talvey on Season 4, Episode 22, and we'll link that one for you as well.
Yeah, and Expert Institute is really the go-to place now for plaintiffs' trial firms to locate the best experts to help them win their case. We've been working with Expert Institute for 4 years now, and they're an indispensable part of our practice. It's really hard for me to imagine going back to a day without Expert Institute. So they're a great company. They provide a great service, and I would encourage you to try them out. Today's show is also brought to you by Smart Advocate. Smart Advocate is the case management software that we use to run our law firm. We've been using it now for over 4 years. All of our staff and our team love it, and it's done a great job managing a complex docket of cases. Some cases are one-offs. We have cases where we have over 100 clients, so it's pretty versatile and a good program and good people. We also had them on the show, right, Robert?
Yeah, I think we may have had them more than once, but I think the most recent episode was with Claude Simpson. It was a bonus episode in Season 3, which will also be linked for you.
Our show today is also brought to you by FileVine. FileVine is a brand new sponsor of the show, and FileVine offers a product called Lead Docket, which is probably the best product on the market for managing new case intakes and leads. And if you're a law firm like ours that spends any dollars at all marketing to bring cases through the door, you know how important it is that you don't want to miss any of those, and you want to have an organized way to make sure your team follows up with every lead and turns any potential case into money to bring money back in the door. So Lead docket is the best way to do that. Check it out and put it to work in your practice.
And I couldn't help but notice you have a shiny new website at GideonAsin.com. Who does that for you?
So our friends at Hype Legal, Micah and Tyler, we just hired them to redevelop our website. They did a wonderful job. The aesthetics are beautiful. The coding is really slick. They do a great job. It's a real pleasure to work with Micah and Tyler because unlike many of the other digital marketing firms, when you work with them, you deal directly with Micah and Tyler. You're not dealing with some young account executive that doesn't know anything about coding or your business. You're dealing directly with the principals. They're very responsive, and they've got a great eye for aesthetics. So check out our new website if you like it. Give Micah and Tyler a call, and they can do the same great work for you.
And I got to say, I'm hearing people say that somewhere around episode 2 of this podcast, it just started sounding a lot more crisp, really good, really professional. What happened there?
You know, it's funny you should ask that, Robert.
I'm the worst.
So we decided finally, after 4 seasons of kind of winging it, and we did an okay job, but we thought we could do better and get better sound quality, have a better produced show. So we finally bit the bullet, and we've hired LawPods to be our official producer. So not only they've been editing the show, but now they're also producing it. So you can thank the better intro, the better outro, and the better sound quality to the great folks at LawPods. And if you're a lawyer who's interested in putting together a podcast for yourself, I would definitely give them a call. They can help you out.
All right. I think that's our ads. Let's get back to the content.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
Ben, it's been about I feel like it's been 3 years, and I've just every day I go to my mailbox just waiting for my fresh lobster to be delivered for a bet that you lost. And I realized my co-host just doesn't pay up on bets. I mean, what's up with that?
Wow, I didn't know you were gonna sandbag me with the lobsters today. No, I feel terrible about it, Rahul. Every day I wake up and I think, poor Rahul and his family is not going to be able to have lobster for dinner tonight because I've not fulfilled my bet. I'm going to find a way to get you those lobsters, even if I have to drive them myself from Maine to Los Angeles and bring them to your house.
Too funny. The only reason I think about it is how the Bills just did so good against the Chiefs this weekend, and I was so happy.
I was amazed by that. That was a good one. I was up last night watching the Celtics beat the Cavs. That was a heck of a game. I don't know if any of you guys saw it, but geez.
I was actually at the Phillies Cavs game last week when they extended this streak.
The Cavs they're the real deal this year. Boy, are they good. But Boston was able to cling on. I mean, Boston was shooting about 60% from three-point land, which is not going to happen again. So they still only won by a few points. But in the risk of turning this into a sports broadcast, maybe we should move on to the world of trial law. It's our pleasure today to invite Frank Fratello and David Thompson to the pod. They are both trial lawyers in Jacksonville, Florida.
It is.
Is it Farah and Farah, name of the firm? And I just met Frank for the first time at TLU a month and a half ago or so. You were there. I was very impressed, Frank, that you were there at TLU in Las Vegas over a weekend in which you were, or I guess we met on a Thursday, but you were set to start a jury trial the following Monday. You were in Las Vegas partying. So I thought that was very impressive. And then you went on from there and had a great result at your trial. But before we get into that specific case, you had told us in the workshop that we were doing how you had recently decided you just wanted to start trying more and more cases. And I think in the lead up to TLU, you had tried, I don't know, a dozen cases in the last several months or something. And how did you make this conversion to this, moment where you decided, I'm just going to start trying case after case after case and honing my skills and becoming a top tier trial lawyer?
It was an interesting conversation. My bosses are the Farah brothers, Farah and Farah, here in Jacksonville. They have a large Southeast firm. It's Georgia and Florida, many offices, tons of cases. We as a firm have not generally tried a bunch of cases. So you both being in law can understand what that means for a firm that has a lot of cases that aren't getting tried. There's ones that have to be tried or should be tried and aren't. The Farah brothers sort of came to me about 26, 27 months ago and said, what do you think about teaming up with somebody and doing this, have a trial team where you guys will take over. We believe in you. We think that you can do it. I had done maybe once a year a trial for the firm on my own, and I've been here 11 years now. So, I've done 6 or 7 cases. Obviously, we'll exclude the COVID period. For 2 years, there were no trials in Florida. I said, sure, let's try it out. And that journey began in November 2022, and it's ramped up. And now my trial partner, David, who's been with me for a year, we've been the trial team that we just crushed it this year. That was our 10th verdict, I think, in October. And we had 1 mistrial and we had 1 case settle. So, it's been a ton of cases this year alone.
That's amazing. So do you work up cases anymore, or are you the official Farah and Farah trial team that just goes and does one right after the other?
We're actually doing both right now. So we do have a small caseload that we're sort of closing out. And these are just sort of cases that we had either myself or David had individually before we combined up in January of 24 to be the team this year together. And the foreseeable future, we'll keep doing that. But once we run down our cases, I think the plan is just to try cases. So we don't work them up much. We come in, I say about 30 to 60 days. David likes 90 or more days. So we ended up doing 60, a fair compromise between the two of us. But we basically come in the last 2 months, and then we hopefully fix all the problems and try the cases and get a great result.
And David, tell us how you came into this. Were you excited to start trying cases? Were you trying cases already? What was your background?
Oh, sure. So I was a career prosecutor here in Duval County. Left there and went to try. I worked for the biggest insurance company in house, and they were a trial firm there. So we tried cases there. Left there, went to another trial firm, plaintiff side, before coming here in November of 22 or September of 22. So I've been trying cases. I'm board certified in civil trial law. So I think there's like less than 1% of the attorneys in the state. So we just try cases. So Frank came to me and was like, you want to just try cases? And I love being in trial. So, like you said, we're just kind of working down the caseloads that we have and we just pick them up. I do prefer more than 60 days just because people who don't try cases don't know all the issues that they're missing. So when we get the file and start going through it, it's like there's usually a lot of things that have to happen, loose ends, whatever, but we get it done and we take them to trial.
What do you guys find are the biggest problems you're seeing in a file that you're getting for trial in terms of the workup? If you were advising your folks on things they need to improve to get it ready for you guys to hand it off, what would be the top couple things you'd tell?
How long is this podcast? No, I'm just kidding.
Yeah.
No, I generally, I think that every problem can be solved. Okay, so that's always my starting point with picking up a file. But generally, the problem is that if you've never tried a case, you don't know what the end point is. And so those people that try cases like yourself and Rahul, you understand that there's a theme that's worked from the beginning all the way to the end when you finish your closing argument. And these cases are sort of put together in a scattershot way without any real rhyme or reason. And I think that that's the biggest difficulty, is coming up with the theme or the best way to navigate the problems that exist, because there's problems in every case, we can all agree, where that theme or that sort of straight shot between all the problems isn't there already. Basically we have a chessboard that's already laid out and we don't know how to get to the end. So that's the most difficult part for me. I can forgive everything else. Everything else is solvable.
I think discovery, honestly, like people don't understand how responses to discovery can get used against you in trial. So they kind of do it loosey. So then trying to go through all that and make sure all that's tight. And then also just making sure you've done the depositions of the people that need to get deposed. I believe that depositions are basically the trial. So people kind of go in there and either don't do them or don't do them enough, I guess. And those are kind of the harder parts, but I tend to agree with Frank. Most every issue that we come up with, we've figured out a way to get around it. So we problem solvers is the biggest part of what we're doing. But I mean, just making it, we just got to get it to the trial and then go do what we do.
What are the rules of discovery in Florida? Are you able to cure anything in those 60 days leading up to trial, or are you stuck with some things?
That's why I like the more than 60 days. Some of our judges have longer lead up times in their trial orders. So you get at 60 days, some judges, you can't file things or it's harder to amend certain things or you're at risk of losing your trial date. So that's why I prefer a little more time, just because if we come in and they didn't list a treating physician or they didn't list something or an exhibit or whatever that needed to be exchanged, we have time to fix those errors. So that's why I prefer the longer lead up time.
I'm assuming now you're able to do some internal education so that the folks working the cases up are going to do a better job checking all the boxes you need before they transition over to you.
Yeah, we've been able to meet with all the litigators. You know, we have about 100 lawyers. Most of them are handling cases in litigation, which is nice. And they're all very open to the training. And we have many great lawyers here with lots of experience, even if they don't try cases. So working up the cases and educating the younger lawyers how to work up the cases doesn't just fall to us. There's at least 10 lawyers that can then help train. And we run actually monthly training sessions in the firm. So it's really it's a nice group dynamic that everybody's willing to listen and learn. And we have enough people to teach. So you get a number of different viewpoints on it.
So you've had kind of the crash course, especially you, Frank, in just getting a lot of reps over a very short period of time. And I'm sure that that comes with a lot of growth and a lot of insight that you've had and evolution of your own approach to trials. Can you give us kind of some of the high level takeaways that you've had from that number of reps and what you think you've learned and how you've grown and what you're doing that's different today than might have been 22 months ago?
I'm a different person completely, and as well as a different trial lawyer. First and foremost, even though you know the details are important, you can always do more work on the details. If I have any great thought about that, I just look to David. He is the details guy. He is always super prepared. There is no one in Northeast Florida that gets more prepared for a trial than David. So that is a very, very big part of what I've tried to do more of. I definitely believe that we have to take advantage as plaintiffs' lawyers of primacy. And our whole case needs to be our best case. I was always used to be worried about, well, I need to meet all these defense points. I need to flush them out beforehand, because if I say the first thing, no, I'm not sure that that's the way. That's the biggest difference between 22 months ago and now, is I don't get mired down or bogged down by the defense's case. I really do focus solely on our case. And then in cross-examination in their case, that's when I'll deal with their points. And that's why I really like the cross-examination class you taught, Ben, is it really gave a powerful way to deliver high-level sort of rebuttal of the defense's case, which I think has been working in the last few trials we've done. But that's the biggest difference, is I'm not distracted by the defense's cases anymore.
So on your first trial this year, then how would you have presented and when would you have gotten mired in the defense arguments, and how are you avoiding that now? Is it an opening statement or voir dire or?
Yeah, it's in jury selection even. I think I took the bait on some of those things, talking about, I know we have to touch on things, but I think focus too much on cell phone use and things like this, when the case was pretty simple. It was, our lady's going straight through a green light and a woman makes a left turn in front of her. What else is there to talk about? They can get up and talk about all the excuses they want, but I think I may have given them a little bit too much credence in jury selection. So I would definitely change that. Absolutely.
Can you guys maybe give us a couple of examples of cases and maybe talk about how they were when you first found them, when they were handed off to you, and then some of the issues you had to deal with and how you solved them and presented those cases at trial and what in your results?
I'm going to pass that one to David because he is an expert on this piece.
Okay.
I mean, most of the trials we get, truthfully, because of the training that we've been able to do since the beginning of the case, or a year, a lot of the attorneys have been fixing most of the issues. There was one case that we realized that maybe the response to the complaint wasn't ever done. So, I mean, we had to make sure that got taken care of, or, sometimes is the right defendant the person who sues, especially in issues where you have, company defendants and stuff like that, just to make sure everything's tight that way, to make sure the pleadings are accurate. I think that was kind of the bigger one.
You just want a collectible judgment.
Collectible judgment, right? Yeah, we can do all the work, but if you can't get anything for it, it's kind of, I don't know. So I think that was. Other than that, it's a lot of it is discovery issues. It's like, why didn't you depose this person? We don't want a loose end. Let's just see what they got to say. Maybe even send an investigator to go talk to them. Most of it's that. Like, you have a 3-car crash, and then comes the turn, find out that the defense is actually, well, it was the third car, and the third car is like, no, they rear-ended me too. Like, why don't you talk to that person? He'd probably help you out. So things like that. I think that's more of kind of what we're coming into. But I mean, like Frank said, most of that's an easy fix. We get some depot dates, tie up those loose ends, and then keep the train on track.
So can you give us a rundown of the 10 verdicts that you got?
Oh, yeah. So we had, let's see, we've got, and by far, most of the cases that we've tried are non-surgical, right? So they're pain management cases, which for me, I always think that they're difficult, really difficult, for one very easy logical position. And that is, if I need a lifetime of pain management that's going to minimize my pain, as a jury, why the heck do we need to give you pain and suffering or non-economic damages? It's sort of like a logical inconsistency to me in pain management cases. And in Florida, we have a peculiar law that requires us to prove permanency. Okay. And when you don't have a surgery and it's a facet-based injury that they're treating with pain management, it's really hard to show an MRI finding or anything that'll come in and say, that's a permanent injury. So those are two really big hurdles. And then you obviously have the third one, and that is the client looks completely fine, especially if they're getting the treatment that they're recommended, right? I mean, they don't, our last trial, and we'll get to that later, but she was still working out, at the time of trial. So, I mean, those issues are there, but we've tried a rear end car crash case for a 27 or 28-year-old that was only purely pain management. And we got a full life care plan, which was close to $1 million, but no real pain and suffering, maybe 50, 60 grand in the past, and maybe the same in the future. So it wasn't even $1 million verdict, but we thought, oh, this is proof of the concept. We can get real value for these pain management cases where insurance companies are looking at them like 100 grand, $150,000, and so obviously we saw that as a place where we can sort of maximize the value to our clients in those cases. And that's really what we've been doing over the last 10, 12 months of verdicts is really those pain management cases. Would you agree with that, David?
Oh yeah, for sure.
Yeah.
I think only let's see, 1, 2, I think 3 of them had surgery, 4, and one of them settled right before closings.
And the surgeries on those 3 cases, are we talking about fusions or partial discectomies or something else?
No, all of them. Well, we had that one. See, we have a cervical fusion, and then one, he was in a really bad crash, and I think he broke his leg, his ankle. What else did he break? That one, Frank?
It was basically the bone above and the ankle. So he had some hardware put in, and it gave him some problems. But even he was, back walking, and they had taken out all the hardware by the time of trial. But that was lower leg surgeries.
I have a question on this permanency issue. What about chronic pain syndrome? Does that not count as permanency under Florida law?
Yes and no. So permanency can be satisfied in three ways. Basically, is the loss of an important bodily function, significant scarring or disfigurement, or the nebulous, anything within a reasonable degree of medical probability that is permanent. So, yeah, your question, Rahul, that would fall into section 3. But as you know, it just becomes a battle of the experts at that point, right? Treating physicians saying, yeah, this is permanent. I've treated them for 2 years. That satisfies our threshold for permanency. And
Is that a standing issue or is it a verdict question on the verdict?
yeah, question on the verdict form. So the jury gets to hear it and has to hear it. And that's only in auto crash cases, right? In slip and falls, we don't have that. But for all intents and purposes, the defense attorneys defend them the same way and highlight permanency in those cases as well. And so the same arguments are trotted out by the defense CME docs or DME docs, whatever you want to call them.
So in a pain management case where there's no surgery, but somebody has ongoing pain issues, how are you guys valuing that case? And what are the discussions with the clients like in terms of settlement versus trial? Let's say you've got $150,000 offer on the table, but somebody needs ongoing therapy or pain management care. Bring us into that discussion, and what is the kind of thought process about which cases you should try and which cases you should settle?
Well, I would say, especially even this last one, I've had her, she was with me from the very beginning. And she was a pain management case. And like Frank said, she got back to walking. She can't walk as far as stuff, but she's getting radiofrequency ablations, which give her a significant amount of time. Unfortunately, her nerves grow back. So in cases like that, we got the life care plan, which was, I think it was like 1 to mid 2s million in the futures. And she got the numbers, and we just had a real conversation about it. The offers were very low, so it makes it easy when the offers are so low. But even when they come back with significant money, it's looking at all the different aspects of trial. What are your futures? What are your past? What can you get? Guaranteed money. We have the conversation, right? It's guaranteed. You don't have the threat of appeal and all that stuff, or you go through and something could happen during trial and they get an appeal and we're bumped further, or it's 2 years later when the appellate court comes back. So we have real conversations with them about the timing and all the issues that could come up in trial. And frankly, it's really every case that you go to trial is going to trial for a reason. There's never that I've seen a complete slam dunk that they're just like, we're just going to go to trial for whatever. There's always some kind of issue. So we're very upfront about what the issues are and let them make the best decision that they can for themselves.
So before Farah and Farah put together the trial team, were you guys basically settling 90% of these cases or more for whatever the highest value you could get pre-trial was?
Yeah, I've been here 11 years, and that was really the model. And before that, before my 11 years, we were mostly a pre-suit firm. Over the time I've been here, they've transformed from a pre-suit firm to a litigation firm. And now they're taking the next step, and that is you got to be on the trial side of things in order to help every case. As the legislatures, especially in Florida, become more hostile to our industry and make it harder to recover past medical bills and future medical bills through a bunch of bad legislation that passed last year. The owners and us, David and I, see trial as really the place where you'll have the most level playing field.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. psrplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at psrplaybook.com and learn from the best.
So I want to hear about this verdict right after TLU.
Well, I think we're going to get some real honesty here, because I'm sure David did not like preparing while I was in Las Vegas, coming home on a red eye on Saturday night. But he's never said one word that I shouldn't have done it. That is, to his credit, he is the best trial partner anyone could ever have. So I'll let him start from there.
Next time, David's going to
Yeah,
Vegas.
I actually know. Was I nervous when I found out Frank was going to that? Yes, but honestly, he got back and he prepped before he left. We prepped when we got back. I was in it, so everything was pretty much done on this one. And truthfully, I was really thankful that he went because he tried a new strategy that he learned there, and it ended up paying out for us. So, I mean, she was a young girl. She got T-boned by big old Frito-Lay truck, or excuse me, not T-boned. She got rear-ended. No priors. They really didn't have much. We did great in the depositions beforehand, so we knew their experts were pretty much giving us causation and permanency, truthfully. So we just kind of went in there and rolled the dice. We actually ended up calling one of their experts in our case in chief. Turned out good for her after that week of trial. So,
as I recall, one of their experts was either a neurologist or a neurosurgeon.
Yeah, he's a pain man. Well, I know he did have a neurosurgeon also, which he was frankly completely nulled him out of the trial from. So that was one of the best crosses that Frank's ever done. And then their other one was a pain management doctor who they kind of disagreed. So I was like, well, helps us. They're not even on the same page. So that was pretty solid. I was actually thankful afterwards. Like, yeah, he learned everything that he used in Vegas at the trial. So it worked.
How long was the trial?
Started Monday, and the jury came back Thursday.
Oh, that's fast.
Yeah.
So how many witnesses did you have?
I think we did 7 on the first day and 5 on the second day. And then the defense only had 2 witnesses.
And then you end up getting your jury. How long do you have for voir dire and getting that jury sworn in?
This judge is a little bit strict, so he only gives you a couple hours, and really he counts the breaks in those couple hours that we had. So in about less than 90 minutes, I had done jury selection, and we actually got through to, did we do openings on Monday this time, or did we wait till Tuesday?
No, we did them Monday
Yeah.
night.
So we even got Monday night opening.
So Sunday you come back, Monday pick a jury, do opening, implement TLU strategies, and then put on 12 witnesses over the next couple of days.
Yeah.
He's a rock star.
It's all him. It's
You guys make a great team.
We do. I couldn't have asked for a better trial partner, honestly. Like,
how do you guys divide up the trial?
50-50 usually. And that's the most interesting thing is I, as most trial lawyers are control freaks, I'm sure. And I have a hard time letting go of work. But David, if he takes something and wants to do it, I don't even need to look at it. And I think it's the same for him. If I do something, he doesn't even really ask about it unless we want to brainstorm an issue.
The strategy there is great. Honestly, it's part of trial. Obviously, if you go to someone who's never been, it's like you got to make sure that they're doing theirs right and you're doing yours right. But when we split everything up, and we have all our cases listed out, so we kind of like, hey, you take lead on this case, I'll take lead on this one. So on those cases, you make the order of proof and just put whoever's doing what, and then we just go out and do it. But the comfort of having a trial partner where you can just be like, hey, go take you got the doctor and you got the pain management radiologist, or you got jury selection and closing, or you have the opening. You just tell them and they do it. And you don't have to worry about it. It's just so much easier to focus on your stuff. That's invaluable.
So on this case, what was the pretrial offer? And then what did the defense recommend at the jury award? What did you ask for? And then what was the outcome?
It was a pretrial. It was like a 175. It was low.
It started at 75, and then I think they came to like 150.
It was very low. So we were like, the whole time we were like, we're going to trial. And then I think they told him to give him about $1 million. He just pulled a number out. I think he said to give him $1 million. We were much higher. Was it 5?
Yeah.
What'd you ask?
We asked for like 5 or 5.5.
They gave 2.5, 2.125, something like that. So
amazing.
It was great. And then, I don't know, in Florida, we have proposals for settlement. So we beat our proposal for settlement. So then they have to add the attorney's fees and costs on top of that. So
you get the contingency fee as your fee in Florida?
No, it's hourly. They add whatever hours we document that are reasonable and necessary to prosecute the case and what our reasonable hourly rate would be. And voila, that gets tacked on to the judgment or the final judgment. It's a really good leverage for resolving cases pre-appeal. I'll tell you that.
Yeah. Only reason I asked in Nevada for an offer of judgment, if you beat it, you're entitled to add your contingency fee.
Wow. I think that's the way it is in Georgia as well. So that's a similar thing. If you get an OJ that is triggered, you get to add your contingency fee in.
Well, that's amazing. So did they not offer you $1 million during trial? They just suggested that to the jury, knowing that they're probably going to have to pay more than that?
I mean, I think we knew that they would offer us the money, but if you're not accepting it, they're not going to give it to you. We just kind of said it's not enough. We knew, and our client, it was actually really good because our client was like, she had a number in her head, and if they weren't going to offer that number, then she's like, let's just go try it. The whole time, she honestly didn't want to resolve the case. She said the whole time she just wanted to go to trial and have her day in court. So I was like, well, we will much oblige you. So, it's always interesting. I learned a while ago, it's something you got to turn down $1 million to make 2 or 3, So when it comes to those conversations, you just have a real conversation with them and what you think the value is. But if you try enough cases, you all know some go sideways on you for whatever reason. And then some, you win some, you should lose, you lose some, you should win. So that's always a conversation, but she was very adamant. She wanted to go all the way. So if they weren't going to come up to where she want and they weren't, then we just try it. We did better than her number. So we're good.
Yeah.
So Frank, you said you had tried new things you hadn't tried before. Tell us what some of those were.
Well, specifically,
and David's laughing, so
yeah.
I don't know. Maybe David should start out. Well, from your perspective,
I
David,
think he
what
should.
did you see? What did you see that you hadn't seen before?
Well, Frank came in and said he was going to do like a 10-minute jury selection. I got kind of nervous, and he's like, he was very excited about it. Maybe it was 30 minutes. He was extremely excited. He's like, I'm doing it. I talked it out. He's like, well, I'm doing it regardless. So whatever, it doesn't really matter. So I was like, you know what? Let's go do it. And he went and did it, and it was actually quite effective. I was impressed. Frank, everything Frank does is impressive. So he did it, and now I know, as you go through trial, the more you do something, you get better at it. So I'm excited to see it get perfected.
Yeah. So I saw Sari Motte in Las Vegas, and I listened to her workshop, where I was in her workshop with her, and we worked on sort of the jury selection method that she uses. And the highlight there is the money damages piece. And to be honest, nobody likes talking about money. I know that's another thing that has changed drastically for me is in the beginning, I treated money as sort of like this evil secret that we were all scared of. And now with this new method, and in the last couple of jury selections, even before that, I've embraced it. And I think that's another big change. But Sari's method just sort of spoke to me about how to do the money damages. So that was the primary part of my jury selection. And it's because of that logical inconsistency we were talking about. It's easy for people to give money for the things that you are going to need in the future. We were fairly certain that we would get a lot of money for that. But how do we take that and then get a whole lot of non-economic damages? And in this case, half of the verdict was non-economic damages. So they matched almost precisely what they gave in future medicals with pain and suffering, which blew my mind. It was always what I was scared of in these pain management cases, but they did it. And they did it for a girl that testified she could do pretty much everything for at least 4 or 5 of the 6 months her radio frequency pain relief was working,
I'm sorry, just tell us, how do you do that?
Sure. So
what's the strategy there?
It is an inclusive sort of voir dire. She doesn't believe in attacking anybody or trying to get anybody off. There's intervals of questioning, and at every interval you check back with the jury and say, would you still be willing to listen? Are you still willing to be here and be part of the case? And essentially you're getting buy-in from step one. So you start by saying, what does everyone think of jury selection? And of course you get a bunch of groans and say, oh, your lawyers are just trying to twist our words to get us thrown off so you can get the best jurors. And in your head, you're going, yeah, that's exactly what I'm going to do. But what you tell them, not really, I only joke, but what you tell them at that point is, well, I'm going to do it differently because I don't think that's the way it should be. I think you all should decide based on the principles we're going to talk about here in jury selection, whether you want to be a part or not. And I'm going to ask you at intervals along the way and at the end, if you're willing to stay and be part of this jury. And then you have 2 caveats. One is, I don't have full control, right? I don't get to make the decisions. The defense attorney and the judge ultimately get to make those decisions as well. And secondly, I don't get to tell you about any of the facts. So you'll be frustrated along the way in this process. And so it really sets up what's going to happen. And then after you finish with any particular principle that you want to talk about, you ask them, who here still wants to stay? And people will raise their hands, some people won't. But you only call on the people that do and ask why. And the answers you get are just incredible. Like we were talking about personal responsibility. And that was one of the things we thought was a good piece for us in this case, is that they're saying, yeah, we caused the crash, but we don't think she's really that hurt. When I asked somebody after that piece of the jury selection, I said, why do you want to be here? He goes, because I want to make people that don't accept full responsibility pay. And I was like, oh my gosh, yeah, this is the guy. And so we got all the way down to the money damages. And essentially you take that personal responsibility piece and you ask them, well, how do you do it? There's things that have price tag and there's things that only have value, right? So you're talking about economics and non-economics. And you put the price tag stuff on one board, you put the value stuff on another board. So you sort of separate it, which it'll be like that sort of on the verdict form. And then you ask them about it. Why are these things important to you? And invariably people say the value is priceless for those freedoms, you know, that could get taken away. Like if you can't go out fishing, you can't go out boating in Florida. These are some of the things people like to do. If you don't have individual freedom, if you don't have the ability to walk as far as you want. I mean, all of these things came from the jury. I didn't have to suggest any single one of them, but they immediately became the themes in our case. And at the end of that, I told them exactly what we would ask for, the number. And then you immediately ask them afterwards, who still wants to be here? And incredibly, about half of the jurors raise their hand. And you ask a few of them why, and they all say, I want to know what this case is about. I want to see if this case is really worth, I think we said $5.5 million, you know, and they said, yeah, we want to be here. And then the best part happens at the very end. You say to the people who don't want to be there, well, why don't you want to be here? And they say, because I would never award any non-economic damages. Oh, thank you. Next one. And essentially they struck themselves for cause, 15 of them, right on that last question, when they didn't raise their hands. And you know, you got all sorts of venom about how much you're asking for. You're a greedy plaintiff's lawyer. I could never trust you. I could never rule for your plaintiff. Great. Thank you very much. And you move on. And the judge granted every single one of those people that made those statements. And we ended up with a panel of the people who raised their hand, wanted to be there. The defense used 3 of their strikes before we ever used one. And the most important thing that I've never seen before in any of my trials, you know, done 35 now, the alternate juror gets released before deliberations occur in Florida. And there's only 6 jurors, so the 7th alternate goes. He stayed for deliberations. Not only did he stay, they started Wednesday night and they asked to come back Thursday morning. He came back Thursday morning, the alternate juror. And I just knew at that point, this method worked. I had formed that group through jury selection, and they deliberated for 6.5 hours over 2 days, and the alternate came back the second day. I just thought, this is something that has to be used. And sure enough, it worked out.
And that whole process took 90 minutes, you said?
Probably less than 90 minutes if you count the breaks.
I'm curious, Rahul, what your thought is, because I know you're sort of known for your knowledge and teaching and approach to jury selection. You use a different approach. But have you heard
I love
the Sari
things.
Motte approach, and what do you think about it?
I have, and I really like the way Frank presented it here, and it sounds like an incredibly effective way to go about it. The only concern I always have with some of these things is if you have a really in-tune defense lawyer, then potentially they have the ability to get a number of those people that you've had raising their hands the whole time off for cause. But I assume that most people are not prepared for this type of voir dire coming their way. And you talked about it at the beginning, Frank, that you're a big fan of embracing primacy. And so having now done 90 minutes or less of voir dire on all of these issues, it may be really difficult for a defense counsel in the same or less time to unravel what you've already wrapped up.
Yeah, it was actually exactly what you're saying happened, because the defense attorney got up and he went 1, 2, just one by one, says, what do you think about lawsuits and greedy lawyers? That was the only voir dire he did. And what he got from these people were, yeah, we don't believe in frivolous lawsuits. We don't believe in them. We don't believe in frivolous lawsuits. And I reached over to David and I said, as soon as you stand up for opening, you put up you put up, they agree they hit her, they agree they hurt her, and they agree it's permanent. And you just write next to them their driver, their lawyer, and then their doctors. And that's what he did. He got up and he said it. And so their whole voir dire went whoosh, right down, because this is now a legitimate case, right? He had no clue what was coming, and he stepped into it right there. So, I mean, I do think that was exactly what you're talking about, that phenomenon. Just really, he wasn't prepared for it. But I fully expect that there will be some in-tune defense lawyers that do and can do something with it. But you still get that first statement and opening, which I think will drive back the principles that you elicit in the jury selection, which it's their words. So when you parrot back to them what they've already told you, how can they break free of that and go to the defense? That's the theory behind, or at least that's what Sari says about that theory is, you can deal with it in opening because you get not only first in jury selection, you sort of get the rebuttal to jury selection in your opening. And that's how she treats opening a little bit. So
how fun. And then, so now with the opening, David, do you use PowerPoints? Do you put up exhibits, or is it, how do you do it?
Yeah, I do all that. So I'm a big believer in PowerPoints and like visual as well as audio, just because everyone learns a little different. So I do the PowerPoints. I show them the photographs. Go through our case, like Frank was talking about earlier. I try not to really focus much on the defense case. I tell them about our case and why, she's hurt and where it shows it, pull up the records with highlights and all that stuff. And then I usually touch on the defense, what they might say, but that we're going to put it in clear context because you got to use it with everything. Don't take it in a vacuum or out of context. And then we wrap it up, bring it back together in closing. So they hear it again. They hear it in the opening and the closing and say, we told you they were going to just show you that one record out of, 3,000 pages, but look at the next page they forgot to show you and stuff like that. So we make note of whatever they do in their opening as far as the exhibits, if they choose to use them. But I usually just focus on our case and use all the show the injection, show a timeline, show kind of what the life care plan is, all that kind of stuff, and just put out them before so they know the roadmap, which we're going to be getting them to with the doctors.
Is that like a 30-minute or hour-long opening?
It's usually about 30 minutes. I think we always ask for 45, but I think 20, somewhere between 20 and 30 is usually where I land.
You guys do focus groups or data or do anything to try to project value or to identify the key themes and your defenses?
Having tried so many of the pain management, the defense is really defense by number, paint by number type stuff. So it's really predictable what we see. So no, we haven't done many focus groups this year. I will tell you that when we started the trial team last year, every case was focus grouped. So I did use a lot last year. I have not used data. I'm really interested in that. And I think that it can be very, very helpful. Unfortunately, these cases with the offers pre-suit, they don't really warrant that sort of investment, at least at this point. I know that there is, some new AI apps coming out from the Campbells that may be worthwhile for our sort of $1 million and below, or $1 to $2 million cases. And I'm really interested to see that. I saw that track in Vegas as well at TLU. But no, we haven't done data yet, and not many focus groups at this point.
You've got 30 focus groups that you can work off of already with your verdicts and trials on similar cases. That's amazing.
Best possible focus group. Yeah. So tell us about the crosses. We spent a couple hours together in Vegas talking about cross-examination. What was your approach to cross at this trial?
I took your modules. I mean, the notes I wrote from you in your presentation at the workshop, I just said, be simple, be intentional, and it's more about delivery and what you're asking than what he's going to say. I mean, we already know what he's going to say because we have his depo. So that's not the hard part. It was sequencing it and being simple. And ultimately, I just remember reading it. And the last thing I had written from your presentation, whether I had stopped or you had stopped the presentation, I know there was more discussion, but it was first principles first. And I was like, oh, like that's the basis for everything. So ultimately we worked through the money with the guy and talked about what he did, what he didn't do, what he wished he had, what he wished he didn't have. But ultimately, since they had 2 medical examiner doctors, only one in Florida can physically see your client, the plaintiff. And they had chose the other guy because this is a pain management case. And so they chose the pain management doctor to do the physical. Well, I had the neurosurgeon, and he ended up being their last witness. And my last question to him was, we built up and then said, would you ever do surgery or even treat someone that you didn't see and put your hands on? He said, no, of course not. Who would ever do that? And I was like, the jury's face just went boom. And you didn't do that in this case, did you? And then the look on his face was like, oh, shoot, you really got me. And I was like, the guy's a really nice guy. He's just not, some of these neurosurgeons are really, really smart, but pretty dumb when it comes to common sense. And that's what happened right there. And he said, no, I didn't see him. Okay, thanks. And the jury, afterwards, we talked to him and they said, that guy was a fool. You made him look like a fool. And it was first principles first. And that was what I tied that whole cross-examination theme to, was first principles first. Just, what do you do when you care and treat for someone, and how can you come in here and not do that and try to get someone to believe you? So, and I was short because you said be short. So I was like, yeah, that's a really good idea.
How long was the cross of the neurosurgeon?
Less than 10 minutes. Yeah.
Wow.
It was money. It was a mistake he made about the medicine. That was pretty funny part of the cross-examination. He had said that this couldn't be a true pain management case because they were doing RFAs at 4 levels. And in fact, they were only doing them at 3. But he was counting the vertebrae as the levels rather than the interstitial disc and the interstitial facet joint. And so I got out with a spine and I had him come down right in front of the jury. And the judge was like, what are you doing? I was like, I need him to demonstrate something. And I held the spine and I gave it to him and I said, where was she getting these RFAs? And he goes, oh, these 4 levels. And I go, well, you don't do RFAs into the vertebrae, do you? He's like, no. And immediately, while I'm standing literally face to face to him, he looks at me and he just sort of sneers. And I said, there's only 3 levels that you're doing, right? Because it's 2, 3, 3, 4, 4, 5, right? It's not 2, 3, 4, and 5. And he goes, oh yeah, I must have made a mistake. And then I took the spine and left, and the judge goes, do you want anything more from this witness? And I said, no, he could sit down. And then we talked about money, and then we went to the fact that he never saw the plaintiff, and that was that. But that was sort of on the fly. He gave that to us in direct, and I just seized on it as sort of the first thing to do.
Well, great result. Definitely took some guts to spend your week and weekend before a significant trial in Vegas, trying to learn, but also, I'm sure, spending some social time with Dan and the boys, at a couple of after-hour events. So David was back at the office, slogging through the case and getting you all both of you ready to go there. Next time, David, you get to go to Vegas while Frank gets to stay home and do the hard work.
We actually both went last time, but we didn't have a trial the next week.
Yeah, 2022.
Well, thank you guys so much for coming and sharing your experience with us. I mean, I guess maybe to wrap it up, there are a lot of trial lawyers probably listening who are more like where you were, Frank, before you went on this journey, who were kind of slogging out 1 or 2 trials a year, a lot of stress and anxiety, and having long periods between trials where they would forget about what they learned in the last case. Give folks some helpful pointers to get from that point to where you guys are now.
That is a great question. I would say that you need to always prepare, right? That's obviously it, but you really need a mentor, somebody to talk to, bounce ideas off of. So this trial team works, I think, because there's 2 of us of equal caliber. And even though we don't have the Rahul or the Ben on top of us to learn from, we sort of get that from each other. So as a new lawyer, I want you to have somebody you can talk to above you, but also talk to the people that are in the same boat as you, because they're going through the same things you are. They have the same fears, they have the same anxieties, and, learn everything you can, try new things. You'll know if it works or not pretty immediately. And that immediate feedback is probably the best teacher. A lot of people say, you learn more in losses than you do in victory. I think that you learn a lot more out of little losses in trial, even if you may win overall. And you learn from your mistakes. We all know that. So don't be afraid to make them and go out and do it.
I learned very shortly into my career that you might not be the smartest person in the room, and I rarely am because I'm usually doing trials with Frank, and he's way smarter than me. But I'll tell you, as far as preparation goes, my one thing for anybody who's out there is be more prepared than the other side. If you know the facts better than the other side, whenever they say you know your case, your evidence, you usually come out on top. And I learned that as a prosecutor. I've carried that all the way. I've done 89 trials now, I guess. So it's like just always be prepared, more prepared than the other side, and things usually go out your way.
Great advice.
Great advice.
Well, thanks again, guys. It seems like you're having fun, which is an important part of it too.
Absolutely. Thank you all for having us. Appreciate it.
Yeah, I appreciate the time.
No, it's great. Thank you.